But then, if you have ever ordered food through Uber Eats, listen up, because anytime you order a trip through Uber Rides, you might be putting your life in danger with very little recourse. And we know that now because of what happened to John and Georgia McGinty, right? And you likely have never heard of these people because they're just some couple in their 50s who called an Uber back in 2022 to take them home from dinner. But during that trip, their driver ran a red light and T-boned another car, which yes, wrecked the vehicle, but more importantly, it fucked up John and Georgia. John fractured his sternum, left arm, and wrist, requiring a bone graft, though he still has diminished use and sensation in his wrist today. And Georgia, she suffered cervical and lumbar spine fractures, rib fractures, a protruding hernia, traumatic injuries to her abdominal wall and pelvic floor, and that's just some of it, without requiring her to have numerous surgeries and invasive procedures, as well as having to leave work for over a year. So they've got tons of medical bills and financial losses from unemployment, not to mention the physical and emotional pain they've suffered. But their auto insurance, it couldn't cover them because they weren't driving, right? They were in an Uber. So early last year, they do what seems natural in this situation. They sue Uber. But what we ended up seeing was that the company filed a motion to dismiss the lawsuit and compel arbitration, with them citing 3 times when Georgia agreed to an arbitration clause in its terms of service. Once when she signed up in 2015, again in 2021, and once more in 2022. With that most recent one concerning any disputes, including concerns around auto accidents or personal injury. But to that, the couple had 2 responses. One, it was actually their daughter who was and is a minor who ordered food for the family the most recent time and agreed to the terms. And 2, she agreed to the terms while using Uber Eats, not Uber Rides, so it's insane for that to cover all of Uber's different services. With them expressing absolute horror that a corporation like Uber, quote, avoids being sued in a court of law by injured consumers because of contractual language buried in a 12-page-long user agreement concerning services unrelated to the one that caused the consumer's injuries. And if you're getting a sense of deja vu here, yeah, we covered something similar to this a few months ago, or back when a man attempted to sue Disney after his wife suffered a fatal allergic reaction to food served at a Disney World restaurant, with the company then trying to compel arbitration because he had previously signed up for a trial of Disney Plus. Though the outrage then unleashed on Disney forced them to withdraw its motion. And I'll say initially in this case with Uber, it looked like the couple might not even need the media attention, or because the lower court actually sided with them late last year, calling the arbitration clause overly vague and ambiguous. But then Uber appealed that ruling, and now a New Jersey appeals court has sided with the company instead, with them saying that Georgia effectively agreed to the arbitration terms even if her daughter did so on her behalf. And so now you have the couple's attorney telling NPR they're considering other options, including asking the trial court to reconsider the case or even bringing it to the New Jersey Supreme Court. Because in their lawyers' words, this is just yet another arbitration clause that looks to have an infinite reach, eroding consumer protections. But yeah, I agree. I think this is insane, right? The idea that there is a reasonable expectation that the average consumer is going to take the time to read legal documents, a mountain of terms of service when they're just trying to rush order a 25 large box of munchkins at midnight, that's crazy. And then the idea that the agreement made there for pastries, baked goods to be delivered to me should transfer to a different service where I am the thing being transported, that's bananas.